so fast calling this meeting to order, but I'm Cook Okai, also known as Clarence Chang. To start off with, I'd like to dedicate the things I'm going to say today to one of our lately departed brothers, Soli. He has been very supportive of all of our conduct and actions and laws. And in fact, maybe, I don't know if you guys are lucky or not that he has left us, because he may really be doing more damage after than he was when he was here. Additionally, speaking, and I'd like to publicly thank you, Bill, for some of the kuku you gave to the family, and I guess, Coach, I don't know about Coach, trying to keep the family out of trouble, as Soli's usual MO, would have dictated otherwise. Anyway, I'm one of the petitioners here. Nationality, Hawaiian subject, racial and by U.S. definitions, a native Hawaiian, and by conduct, cultural identity, and for this contested case hearing, a native Hawaiian cultural practitioner.
I'm sorry, I'm having a hard time hearing.
All petitioners here, including those who claim to be Hawaiian.
Clarence, stop 1 second. The folks that are outside the door, could we have you quiet down a little bit? The court reporter is having a hard time listening to the testimony. No, Clarence, Dave.
I just can't hear these guys. Hawaiian subject, racial by U.S. definition, native Hawaiian, and by conduct.
Yeah, all petitioners here, including those who claim to be Hawaiian cultural practitioners, were held to be admitted as parties, having qualified for standing by Minute Order Number 6, order regarding standing on May 27, 2011. Furthermore, according to his findings of facts, it seems that the hearings officer used some kind of qualified standing, regular standing, plus an additional standing qualification in regards to constitutionally protected Native Hawaiian culture practice. The HO failed to provide prior notice of his intentions and failed to include such standards for qualification in Minute Order Number 1, a notice of standing and pre-hearing conference dated April 10, 2011, or anywhere else. Such error cannot be tolerated in retrospect. There is no discussion anywhere in the record of HO's finding of facts, conclusions of law, or decision that outlines the specific standards that he would use to evaluate a cultural practitioner's qualifications under the umbrella of constitutionally protected, constitutionally guaranteed protections. The HO further erred by modifying the standards of proof for civil cases by using Hanapi's criminal standards for qualification. To be held to standards that don't exist or noticed must in the least be a violation of petitioner's due process. Additionally, petitioners Mauna Kea Ho and Clarence Kukaukai Cheng were petitioners in the contested case hearing on the Conservation District use application for the construction and operation of 6 1.8 meter operated telescopes. In that contested case hearing, whether or not these petitioners were qualified as Native Hawaiian culture practitioners was at issue. The HO in that CCH hearing found and concluded that these petitioners were qualified for standing with constitutionally guaranteed protections as Native Hawaiian cultural practitioners. This board confirmed that these petitioners qualified for standing, and so did the Third Circuit Court that heard the appeal. Based on the qualification of said petitioners in that CCH and appeal, it is res judicata, and the HO is stopped to re-challenge said petitioners for standing in this CCH. It is especially absurd when the finding and conclusion here is 180 degrees out of kilter, denial of such protection. The law does not favor such inconsistency and uncertainty, and the HO erred. Mary Pukui in Nanaike Kumu, look to the source, Volume 1, page 94 says that in Hawaii's early days, one's name was one of one's most precious possessions, and one's Inoa name was both own property and a kind of force in its own right. Once spoken, Inoa took on an existence, invisible, intangible, a kapu, tabu, becoming attached to the name. An example of this phenomenon in real time occurred when applicant's witness, Wallace Ishibashi, in his cross-examination, 9/17/11, transcript on page 105, was on the stand. He was asked a question about his family's aumakua relative to Mauna Kea. His response was, well, we take it as, again, every family has their own secret in how they do their thing. But yeah, on Poliahu, which we recognize as the location of where we have an aumakua. But I reserve the right to keep that in the family. As for me, in addition to my hesitancy in reviewing the actual names of my familial relations, that word could meet the Hanapi prong 2 test reveals at its very foundations a deep-rooted conflict between the course of the so-called state of Hawaii and long-standing practice and conduct of Hawaiian culture. There must be a simple way to qualify Native Hawaiian cultural practitioners in legal settings than to unreasonably discriminate against their cultural philosophies and conduct, and that is that they don't talk about their genealogies. To refuse to remedy the situation by insisting on the use of Hanapi prong 2, among other things, may constitute a violation of due process and civil rights of Native Hawaiian cultural practitioners of Mauna Kea. The Native Hawaiian cultural practitioners here, in addition to verbal and written statements they have made or referred to, have in addition, upon oath, stated that they, as individuals, are Native Hawaiian cultural practitioners. How redundant must BLNR and the HO be then, in the face of a cultural and or familiar kapu, to not reveal such personal and sensitive information, to insist on requiring additional specific information. To insist on more specific genealogical information would be to improperly discriminate against Hawaiians as cultural practitioners. Do Christians have to swear their genealogies upon oath in order to practice their religion? This illogical conclusion, among other things, seems to be a violation of the Equal Protection Clause of constitutions. Let me state on the record for yet another time that I qualify as the Hanapi prong 2 standard. This is one of my genealogical lines. Interestingly, some of the names on here that I choose not to reveal on this record are names that are also on Sherman Island's genealogy. This really turns out to be one of the more grave issues in this CCH. And I would exhort you to pay serious attention to its resolution, as it will be referred to later in this presentation. After all, the question should really be whether petitioners are Native Hawaiian cultural practitioners, and not necessarily who their specific ancestors are, or when they lived. It should be sufficient to simply state under oath that one is a qualified Native Hawaiian cultural practitioner. Facetiously, should the state start issuing licenses to those who may qualify as Native Hawaiian cultural practitioners? I don't think so. For the HO and BLNR to insist on such a rigid and arid requirement as Hanapi prong 2 and try to coerce Native Hawaiian cultural practitioners here into violating their family kapu with such requirements is preposterous. But getting back to the CDUA, because TNT Observatory Corporation is the party that requires a permit to build the gigantic 18-story telescope, one would expect it to also be the party to submit the CDUA to BLNR, right? Wrong. The applicant is UH Eagle. The CDUA does not contain a single signature of any authorized TMT person. As an additional point of interest, while one would expect the TMT Corp to be the party opposing the petitioners in the contested case hearing, as you already know, again, it is not TMT Corp, but UH Hilo. Of course, with UH Hilo as the applicant, one would then naturally assume that a legal relationship exists between it and TMT Observatory Corporation, right? Wrong again. There is no operating agreement between the two. So how can UH Hilo legally submit an application for a third-party performer that it has no legal relationship with, such party being responsible for completing the proposed project? In a sane, logical, and legal world, the existence of such an agreement would be fundamental, expected, and required, if only to delineate the rights and obligations of the parties involved. The involvement of UH Hilo in the application process seems to be as a volunteer, facilitator, or initiator, with no legal relationship with the party that's supposed to perform all the obligations that would be included with the granting of a permit, if indeed one is finalized. Additionally, UH Hilo, as an entity of the University of Hawaii, holder of the general lease for Mauna Kea, may have a conflict of interest in all of these dealings. Furthermore, that the actual party in interest, the hopefully responsible party that will raise the funds, submit the designs, comply with all the laws, rules, and regulations, and build the building and its instrumental contents, is a corporation without a corporate history, corporate success, corporate assets, etc., should raise an entire battery of questions. What is the TMT Observatory's corporation's corporate credibility and creditability? Not one single iota of this necessary information is in evidence, and no one of consequence, including BLNR, is asking questions about them. So while there is privity, a legal relationship between BLNR and UH Hilo because of the CDUA, there is no privity between UH Hilo and TMT. Therefore, there is no legal relationship between BLNR and TMT. And except for the granting of a CDUP with its conditions, no conduit through which legal communications and relations can take place. It continues to be interesting that, so far, the legal and other expenses for the TMT are over $1 million and rising. Of course, the beneficiary of whatever benefits should accrue, TMT, is picking up the tab, right? Wrong again. It's the University of Hawaii, and you, the taxpayer, who are footing the bill. Furthermore, one would expect that TMT Corp, the performer, would be responsible to produce a necessary environmental impact statement. Well, not so. It was UH Hilo's attorneys who hired the firm during the EIS. And it's supposed that whomever does the hiring also pays for the service. But remember, there's no operating agreement. So how could there be an arrangement? I'm afraid that, again, the taxpayer is footing the bill. Credit must be given to the TMT Corp personnel who creatively engineered this business plan to get these multi-million-dollar benefits and not have to pay for them. There doesn't seem to be any provision for a subsequent payback either, as there is no agreement that specifies the situation. Heck, further examination reveals that TMT doesn't even have a sublease on which it could build a telescope that UH Hilo has applied for it to build. And as a consequence of this situation, the rent that BLNR should be evaluating for adequacy and compliance is nowhere in sight. Will the amount of rent, when it eventually appears, satisfy the recommendations of BLNR relative to the CDUA that states that TMT remains committed to paying a substantial amount for subleased rent? More so, we also need to be reminded that the individual shareholder members, or whatever the constituents of this TMT corporation are, normally by law, not liable for the liabilities of the corporation. In other words, not even the sovereign nation states involved are liable for payment. Benefits with no liabilities. Who said there is no free lunch? Well, it is common, if not a necessary practice, that corporations without a history of successes and inadequate credit rating usually require personal guarantees in its commercial transactions to guarantee full performance for its undertakings in case of unexpected contingencies. None has been provided for or required in this situation. Is this reasonable and prudent on BLNR's part? With little or no practical experience, effective decision-making becomes a real possibility. How does BLNR protect the so-called state and its beneficiaries from such contingencies? So whether it is the applicant, in this case UH-Hilo, or the builder-operator, TMT Observatory Corporation, BLNR should require that one or both of them provide guarantee surety of such proportion to secure and or ensure that, once started, this project will go to full completion. 20% of the fund of the fees collected by the Mauna Kea Land Special Fund, HRS 304A 2170, are being set aside for payment to the Office of Hawaiian Affairs. Precedent has been set. It is suggested that this arrangement be further documented in any CDUP that may be granted. While existing telescopes provide viewing time to UH in lieu of rent, no proportion of equivalent value have ever been shared with the Office of Hawaiian Affairs for its 20% share of all rental proceeds, as far as I know. The proposed CDUP, among other things, does not mention viewing time in any of its discussions. Not only should the subject of viewing time be included in the CDUP, but that 20% of the equivalent value for viewing time to be shared with OA should be mandated. Curiously, TMT will color the pavement of the accessway, the roadway to the observatory, to blend with the surroundings. Yet it insists, and the HO has gone along with the suggestion, that the coating of the dome will be a reflective aluminum-like coating which will reflect the sky during the day, reducing visibility. To claim that a reflective aluminum-like coating reflects the blue colors of the sky seems to be a figment of somebody's PR myth, surely not reality. In my observation, other luminized domes presently on Mauna Kea have always reflected the glare of the sun, but never of blue sky. If the roadway and supporting buildings are colored to blend with the surroundings, then I would suggest, even require, to maintain consistency of argument that the dome be colored likewise. After all, my view of an eventual TMT observatory, if it should be built, will be from Waimea, and the dome, colored like its surroundings, will be more tolerable if blended rather than glaring. Relative to spatial relationships in Mauna Kea, the university moves its different physical orientations either from being close to the other observatories of the summit area or at a great distance from them, depending on the advantages or disadvantages of the issue it is addressing. For example, regarding section 13.530C5, Hawaii Administrative Rules that states, the proposed land use shall be compatible with the locality and surrounding areas, appropriate to the physical conditions and capabilities of the specific parcel or parcels. It is so understandable that the university would take a close-in perspective for this one, that the proposed TMT observatory would be compatible with the locality and surrounding areas of the other observatories, although the actual proposed TMT observatory location is over a quarter-mile away, except for the sub-millimeter array from the nearest other observatory. A quick glance at a map clearly shows how remote the proposed TMT observatory is from the cluster of summit observatories. On the other hand, it's undisputed, paragraph 91 of HO's conclusions of law, that cumulative effects of astronomical development and other uses in the summit area of Mauna Kea have previously resulted in significant adverse impacts. The trick here is to locate the TMT observatory as far away from the summit area as possible so as to argue that TMT observatory impacts will be minimally cumulative to the significant adverse impacts undisputedly having already tainted the summit area. Either the TMT observatory is near the summit cluster of observatories, or it isn't. It cannot be close for some arguments and far for others. After all, one of the laws of physics is that a thing cannot be in two different places at the same time. I can attest to the height of the pool because it is a challenging hike to the top of its summit. While the sheer size of the proposed TMT for a man-made object, being approximately 1/3 of pool polyhouse height, is monstrous. Moreover, how can the addition of the proposed TMT observatory with spatial dimensions, width, length, and height, practically dwarfing the total of other observatories on Mauna Kea, already declared to constitute significant and adverse impacts, not cumulatively add additional significant and adverse impacts, and not violate the threshold of being significant and adverse as the HO suggests. While such mental hocus pocus, along with alchemy and witchcraft, might have attained credibility in the Dark Ages, my modern mind tells me that one cannot subtract or mitigate by adding. The summit area of Mauna Kea is substantially developed. That it occurs in the conservation zone is as mythical as the existence of unicorns. The conservation zone in the summit area has been totally decharacterized by observatories. It is so totally developed that there is no room on it to build a gargantuan facility such as the 30-meter telescope. The character of the summit of Mauna Kea would not be further developed, even if the heart of Waikiki were to be transported to the mountain. But such development is not allowed in a conservation district, and therefore is not allowed atop Mauna Kea. That there are no guidelines in existence regarding development limits on the mountain is a travesty. It was a major oversight to not have been included in the comprehensive management plan. Moreover, that the negative impact on the mountain is characterized by the number of telescopes in the mountain and not by their sizes and heights. The actual impact of their existence seems to be a fallacy. After all, 10 TMT-sized observatories would have a mega impact on the mountain when compared to 10 12-inch sized telescopes. In each case, there being 10 of them. But the actual impact of the telescope is, I would guess, more proportional to the cube of its primary lens radius than by its unitized number. To shift gears a bit, let me suggest that the CDUP process does not comply with the United Nations Declaration on the Rights of Indigenous Peoples, UNDRIP. Although President Obama and the United States had initially opposed signing the declaration, on December 16, 2010, at his second Tribal Nations Conference, he, the President, reversed his early decision and stated that he would sign. And indeed, a query to the White House about how the declaration would be implemented was referred to the State Department. Spokeswoman Tiffany Miller responded by email that there is no simple answer. As you know, the declaration has implications for many agencies across the U.S. government, she said. However, I can tell you that the Obama administration is committed to making U.S. support of the declaration meaningful. Citing Article 32 of UNDRIP, I conclude that this CDUA process is non-compliant with the article. Article 32. 1. Indigenous people have the right to determine and develop priorities and strategies for the development or use of their lands or territories and other resources. 2. States shall consult and cooperate in good faith with the indigenous peoples concerned through their own representative institutions in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly in connection with the development, utilization, or exploitation of mineral, water, or other resources. 3. States shall provide effective mechanisms for just and fair redress for any such activities, and appropriate measures shall be taken to mitigate adverse environmental, economic, social, cultural, or spiritual impact. While I have no knowledge if UNDRIP has been an issue of any appeal in the so-called state of Hawaii yet, I suggest that this board start thinking about the day that it will. In fact, I'll even suggest that the board start paying attention and starting with this contested case hearing. The day of reckoning is here. Amy K. Lear, in an article entitled Looking Ahead, Indigenous Peoples and Free, Prior, and Informed Consent stated, the UNDRIP sets forth the responsibility of governments to gain free, prior, and informed consent of indigenous peoples. for development projects. It has already been cited in national court cases, particularly in Latin America, as support for the requirement that governments seek free, prior, informed consent from indigenous peoples and cease giving concessions to companies until consent is obtained. Thus, although the UNDRIP addresses governments, it will directly impact companies and the university in this case. UNDRIP, coupled with the Hawaiian Kingdom's Instrument of Accession that was filed with the United Nations Secretary General on December 10, 2012 in New York City, that invokes the jurisdiction of the International Criminal Court over Hawaiian territory beginning on March 4, 2013, gives notice that a new paradigm is taking place in Hawaii. The ICC prosecutes individuals and not states for war crimes committed within occupied territories. Only states can accede to the jurisdiction of the ICC, and that Hawaii achieved the international recognition of its statehood on November 28, 1843, by joint proclamation of Great Britain and France, and entered into extensive diplomatic relations and treaties with other states. The justification for the accession was based on 2 points. First, the acting occupying government is not able to enforce and prosecute individuals for violating Hawaiian law, and the law of occupation taking place within Hawaiian territory. And second, the U.S. Pacific Command, the occupier, has refused to hold to account individuals for committing war crimes that have been reported since July 6, 2012. According to the United Nations War Crimes Commission, war crimes include usurpation of sovereignty during occupation, denationalizing the inhabitants of occupied territory, confiscation of property, wanton devastation and destruction of religious, charitable, educational, and historical buildings and monuments, etc. So please take notice that these developments may eventually apply to you. In conclusion, I exhort you to examine petitioner's arguments on the merits and deny the CBOP. And while you're at it, you should reverse the HO's erred findings, conclusions, and decision that the Native Hawaiian petitioners here are denied standing for constitutional protections of all rights customarily and traditionally exercised for subsistence, cultural, and religious purposes, and possessed of lawful tenants who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778. I think this list goes back further than 1778, since there are about 90 generations on here. I thank you.
I'm going to ask the question that I've asked almost everyone else. Should the decision stand and be go forward, will you stop going to Mauna Kea?
I think that's a very good question. But the answer, I believe, cannot just be a yes or no. However, I will go as far as to say I will not stop going to the mountain. However, as poor Case said earlier, every time she goes to the mountain from now on, already and continuing, that there are compromises, spiritual, mental, these kinds of things that we have to make in order to go up there. I mean, after all, these observatories are not invisible, they're there, and you almost have to sort of condition yourself to ignore them. But let me tell you, it's very hard to ignore.
Thank you. Next up is, next up is Mauna Kea Ainaho, Kealoha.
My name is Kealoha Pasoda. on behalf of Mauna Kea and Idaho, myself and my family, my kupuna. Just for the record, I'm going to read from my notes. In October, I had a stroke, so I don't need real accommodation, I don't think, but covering every day and mahalo ke akua, but just so you know, I have a hard time a little bit with words and things, so.
Take your time.
So I just want to say a small pule for opening, because I will be speaking of the sacred things, and then I will end it at the end, if that's okay. Aloha ke akua. We ask you abide with us this day as we speak on the sacred issues. Grant us permission to speak to the sacredness of Mauna Kea. We ask blessings for all and those who have traveled far, may they return home safely, back to their loved ones, and we ask for forgiveness of any trespass that may occur. I will free that prayer when I'm done. Mauna Kea is sacred because in our cosmology, or our worldview, Mauna Kea is an origins place. For us, it is here where the heavens and the earth come together and where all life forms originate from. It is a temple, but not one made by man, but rather made for man, so that man could learn the ways of the heavens and the laws of the earth. And man could learn how do we live in relationship with the earth, and how do we live in relationships to the heavens and to each other. According to our mu'olelo or oral history, the god Kane was chosen by the Akua before him and made him the one who brought down the baskets of knowledge so that mankind could live rightly. In the Kumulipo, the chant of creation, we learned before man was born, mostly all other living things were born before him, thus teaching us our place in the world. The Po, the infinite potential, the great cause of all life, is where we came from. We came later, and all those before us came there from there also. And they become our older siblings. And when they are under attack, we defend them. And we ask that the unraveling of creation not begin. Because after all the science we have on Mauna Kea, we don't have any science that teaches us how to bring our species back from extinction. And that is not permitted, that is not our human right to have. So this is what Mauna Kea represents. It represents our zenith and our ties to creation itself. And it is this basis that gives it its power, and also that it is the sentinel of the Pacific. There is no other like Mauna Kea. So when we ascend to do ceremony, we ascend back through the genealogy of creation to the point at which the Po and the light were given birth to. So before I get into the substance of the issues involved, I have to digress a moment to address the university's latest allegation, and that is that it goes something like, they know that we're Hawaiian, but we never proved it. And therefore have no constitutional protections for our cultural and religious practices that we execute on Mauna Kea, or our Native Hawaiian rights, in other words. You know, I've tried to think of ways to explain the fallacy of this argument without sounding terse, but I can't. So this allegation is simply ridiculous and preposterous. I cannot believe that the university, which is considered our center of higher learning, would take this position, and I don't even know how to respond, but I have to. So these are some of my reasons why that is a fallacious argument and should be struck. First, the university misconstrues the law, attempting to apply a criminal standard to this case. That is where Native Hawaiians use their constitutional Hawaiian rights to launch an affirmative defense against criminal trespass charges. But we are not criminals, and this case is not a criminal case, but a civil case. involving Native Hawaiian traditional and customary practitioners who are attempting to continue to practice their constitutionally protected rights on public, ceded, and undeveloped lands, which is exactly what Pash case was all about, and exactly what the court was seeking to protect against in that Pash case. Further, because many of us, and that is at least Mr. Nevis, Mr. Ching, Ms. Ward, and I have been previously found to have standing not only by this board, but by both a state case and a federal case, more than one state case actually. And so the university is consequently barred from challenging us at this point. You know, the courts can't make flip-flop decisions, so that's our position. So we have 6 other reasons in our briefs, and I won't go into those right here, but I would encourage you to review at least our Native Hawaiian rights section for that area in our brief. So returning to the issues at hand before us today, why we're here before this board. The short answer is we're here today because BLNR said yes when they should have said no. The job of any regulatory agency, including BLNR, is to regulate, and that means sometimes it needs to say no to projects like the 30-meter telescope that are inconsistent with the purpose and mandate that govern the Mauna Kea Conservation District. But we have been coming and asking the same thing for a long, long time, years now, coming to BLNR to ask that they do their job, which is to conserve our natural resources, such as our lands, the animals, to protect the Native Hawaiian and the public's rights. We began in the 90s trying to have input in the UH new development plans, which plan to exceed the legal limits of 13 telescopes allowed on Mauna Kea. The plan agreed upon by not only the university, but BLNR. And if my, sorry, and if my memory serves me correctly, when we first began coming before the BLNR, it was 6 chairpersons ago. We had Mike Wilson, Gil Kaloma-Agaran, Peter Young, Timothy Johns, Laura Thielen, and there was another one, and I can't remember his name. Oh, Alan Smith, and then now you, Mr. Chairman. To find justice, we have had to come before the BLNR in contested case hearings to compel them to follow the rules, the statutes, and the Constitution that are already written. We're not asking for anything new. And that failing, we went to the courts. We went to a federal court, we went to the Third Circuit Court, we went to the Intermediate Court of Appeals. Now, all the state courts found in our favor. I think it's safe to say that we have fulfilled our civic duty. And as Judge Hart affirmed, our rights have been prejudiced because we have had to go beyond our normal duty as regular citizens and engage in these contested case hearings and the court cases. So I just like to point that out. We've had to go and endure all of this because BLNR has acted in a political rather than as a trustee, which is proposed in the Admissions Act and in contradiction of the law. BLNR is empowered to conserve and care for the land, and they are specifically not mandated to be proponents of development, such as the TMT Corporation, and that's why we're here today. The state recognizes the conservation districts of Mauna Kea's importance as well, because they have created laws specifically protecting Mauna Kea, and under state law, it is considered, under state law, public lands are held in trust for only 2 beneficiaries, Native Hawaiians and the general public. The state is but a trustee, not the owner. The public and the Native Hawaiians are the owners. The state holds and has and continues to have an affirmative duty to protect it on behalf of the right holders, the owners who are the Native Hawaiians and the general public. This is affirmed in the Admissions Act. In short, BLNR is mandated primarily to conserve our lands and natural resources, period. So we're here because the Constitution affirms that Native Hawaiians have a right to continue their traditional and customary practice on public lands, and because the public has a right to a clean and healthful environment, and BLNR is required to protect that on their behalf. But this is not what's happening. What's happening is that BLNR has not chosen to protect those rights that they're mandated to protect, but they're there to protect the rights instead of the residents of Pasadena, California.
Right.
The residents, more specifically, of the corporate members of Pasadena. The rights of citizens of other countries like Japan, France, the United Kingdom, instead of those who the laws were there to protect. We know foreign citizens have no rights here, or at least land rights. So the real question that needs to be answered is, what law is BLNR relying on to give non-taxpayers, non-citizens, not only the right to use our land, but the right of destruction of our land? And what laws are you relying on to give foreigners the right to pay only $1 a year in lease fee? That's a question. What we do know is that BLNR has a non-transferable duty, and that means that it cannot be given away to the university or anyone else to protect the public's rights and the reasonable exercise of traditional and customary Hawaiian religious rights. That also means they cannot let private entities like the TMT Corporation or the university, a subdivision of the state that is not mandated to oversee the conservation district like the university, to perform these duties. BLNR has an affirmative duty to protect the people, as the Supreme Court has repeatedly upheld. We believe the evidence in this case demonstrates that the TMT project is inconsistent with the laws and the policies of the state. And to understand, we need briefly to trace the origins of BLNR's responsibility to the people of Hawaii, and that is the identity why BLNR has, exactly why the BLNR has a fiduciary duty. It begins with the Admissions Act, the state of Hawaii's constitution, and all related statutes and rules and regulations governing the conservation lands of Mauna Kea. So let us review. The Admissions Act is a federal act, a compact or agreement made between the United States Congress and the people of Hawaii, thus forming what is known as the state of Hawaii. And regardless of the tenuous history that led up to the statehood, the Admissions Act clearly identifies certain agreements made by America, and they take precedent, and they shall establish once, oh sorry, did I miss something? Hold on 1 second. Let me go back. Yeah, identifies certain, agreements made between America and the people of Hawaii, and they take precedent as they establish some of the fiduciary obligations that BLNR as a state agency has to the people of Hawaii, and at a minimum, the state must follow its own laws. The Admissions Act established the lands of Hawaii are to be held in trust for the purpose of the betterment of the condition of Native Hawaiians and the general public. The state shall be the trustee, it says. In other words, the lands of Hawaii must be used in a manner consistent with the Admissions Act, and again, a federal law. I would like to take note that the racial identification for Native Hawaiians came into existence in 1920 and 21 when Congress made the 50% blood quantum requirement for Hawaiian homelands. However, the Admissions Act provides for the Hawaiians of less than 50% and other actual subjects of the kingdom of all ethnicities. Hawaiian is a political identification, not a racial one. Now, the Mauna Kea Conservation District lands are entirely comprised of those public trust lands that are identified by the Admissions Act. However, these lands have protection not only under the public trust laws, but under the conservation and historic preservation laws of the state of Hawaii as well. Therefore, in considering the TMT district use permit, BLNR must consider how those proposed projects like the TMT benefit the people of Hawaii, better the condition of Native Hawaiians and the general public, not the interests of the international astronomy industry or foreign direct investment to be subsidized on public lands by the taxpayers. The state constitution contains in Article, I think it's 12, Section 7, affords the protection of Native Hawaiians' traditional and customary rights, while Article, I think it's 11, Section 9, provides that all the people have a right to conservation and a clean and healthful environment. So when the question arises, should a new telescope project be approved by the BLNR, we must consider their obligation. But did BLNR consider it? Well, when the TMT proposal came before BLNR, the DLNR staff affirmed, and I state, from a cumulative perspective, the impact of past and present actions on cultural, archaeological, and historical resources is substantial, significant, and adverse. These impacts would continue to be substantial, significant, and adverse with the consideration of the TMT project and other reasonable foreseeable future projects. Further, the former DLNR chair, Ms. Laura Thiemann, states, and I quote, "It is our view that the effects of astronomy development on cultural resources and on the landscape of Mauna Kea has been significant and adverse. While a project such as the TMT can bring new resources into play that might mitigate certain cultural impacts and even benefit Native Hawaiians, we believe that the project will increase the level of impact on the cultural resources, which remains to be significant and adverse." So therefore, what is undeniable is both the state, BLNR, and the university admit the record demonstrates that if built, the TMT would contribute to significant and adverse and substantial harm to the conservation resources of Mauna Kea, including the cultural and natural resources, which are public trust resources and must be protected. What BLNR and the UNH admit, we need not prove. The conservation laws, the rules governing the conservation district or in this case, development of yet another telescope allow for this contested case hearing to happen. Generally, the purpose of a contested case hearing is to afford members of the public with specific interests, legal rights, and duties an opportunity to present evidence, examine the witnesses, and so on, in order to help BLNR make an informed decision. I have to note here that in this case, BLNR approved the TMT permit prior to conducting our contested case hearing, which we believe violated our due process rights, potentially shifting the burden of proof and thereby forcing us to have to change BLNR's mind, rather than BLNR listening with an open mind to hear all evidence. A contested case hearing is not a motion for reconsideration, and just as a court does not conclude a case before hearing all of the evidence, BLNR has erred by approving this permit prior to hearing all the evidence with an open mind. Nevertheless, the university has rightly affirmed that they, as the applicants, have the burden of proof, and we are here today to provide evidence and present witness testimony to help BLNR make an informed decision now, before they dispose of more public lands and conservation lands belonging to the people. So, according to the rule 183C-1, the purpose of a conservation district is, and I quote, "The legislature finds that the lands within the state land use conservation district contain important natural resources, essential to the preservation of the state's fragile and natural ecosystem and the sustainability of the state's water supply. It therefore is the intent of the legislature to conserve and protect and preserve the important natural resources of the state through appropriate management and use to promote their long-term sustainability and the public health, safety, and welfare." The law is clear. The purpose of a Mauna Kea Conservation District is conservation. The purpose is not development. Development can occur if and only if the critical cultural resources are conserved, protected, and preserved. In order to determine if BLNR meets its legal requirements and obligations, they are supposed to apply a set of rules called the 8 criteria, and they all must be met. Along with the 8 rules, there is one other condition, and that is that applicants shall have the burden of demonstrating that they have met all of these conditions, which also means it is our job. It's not our job to prove that impacts will occur. It is the university's job to prove that they won't. So we submit. The evidence has shown they have not met their burden under the law. Number 1, the TMT project does not meet the first criteria. It does not meet the purpose of a conservation district. Again, they admit the cumulative impacts of the cultural and natural resources are substantial, significant, and adverse. Further, in order for the TMT to be built, the land will have to be hoe-rammed, dynamited, bulldozed, and other heavy machinery used to carve up and destroy more than 8 acres. So we would submit it does not. It is not consistent with the purpose of the conservation district. Second, the TMT project does not meet the second criteria. It does not meet the purpose of the subzone because no subzone purpose can override the first purpose, which is conservation. While, what's that? Oh, thank you. While astronomy is a permitted subuse, again, it is permitted if and only if no substantial adverse impacts occur in the conservation district. But the university has already admitted that it will. And that it will have adverse impact. The TMP project does not meet the fourth criteria, prohibiting substantial adverse impact. The evidence has demonstrated that there not only is historical injury, but continued injury, and there will be additional injury if the TMT is allowed to be built. Further, the university and BLNR have already admitted that it will have adverse and significant impact. And again, what they admit, we need not prove. The threshold has been reached. There's no condition in the rules that say any project can have really, really, really bad impact or super, super adverse impact. The threshold is adverse and significant, period. The TMT project does not meet the fifth criteria because it is not compatible with locality and surrounding area. If the TMT is built, it will sit right smack and dab in the middle of what's called the ritual landscape or the ring of shrines that surround the summit cone, also known as Kukaha'ula. These features are part of the historic district, which contains many cultural and traditional properties, which is further affirmed in the cultural impact statement. In fact, while the TMT, putting the TMT on, while it's cited as being a mitigation measure, putting the TMT on the northern plateau is not set out to reduce the impact. And the TMT is so big it can't actually fit on the summit. So what's really happening is astronomy development is now spilling off the summit onto the plateau, thus increasing the intensity of the land use, which I think is the seventh criteria. So, the TMT project does not meet the sixth criteria also, protecting open space or natural beauty, because it does not preserve or improve upon the natural characteristics such as the open space or the natural beauty. The operative words in natural beauty is natural, not industrial beauty. The operative words in open space are exactly open and space, meaning exactly that, open space. There's no simple way, there's simply no way that this telescope can meet this criteria, no matter how much the university places a spin on it. And there's no way an 18-story high building with 8-acre footprint it just simply cannot, I repeat, cannot preserve the open space characteristics, natural beauty, or improve upon them. The TMT does not meet the 8th criteria regarding the public health, safety, and welfare, which requires the project not to be materially detrimental to public health, safety, and welfare of the people. We heard UH witnesses testify that the complex hydrology, including the groundwater flows of Mauna Kea, are not known. We heard also that Mauna Kea's groundwater is our primary source of drinking water for Hawaii Island. Mauna Kea sits over 5 aquifers, and the problem that we have here today is while someone can promise that they will not hurt or damage the aquifer, if it is damaged, we have no way to clean it up. What happens if mercury spills again? Diesel fuel, jet fuel, or any of the other hazardous materials used by the observatory spill? Who will be responsible? The government of France? The United Kingdom? The state taxpayers? So, the BLNR can't really easily answer these questions, and they should err on the side of caution and use the precautionary principle under the public trust doctrine prescribed by the Supreme Court. In the absence of proof, we must rely or err on the side of caution and rule on behalf of the resource. Mauna Kea houses the water that the life forms rely on in Hawaii altogether. There is uncertainty. Witnesses have testified to the cultural and religious importance of the water of Mauna Kea, like the snow, ice, and clean water, such as those found in the lake, and other pu'u for ceremonial, medicinal, and other religious purposes. Those practices will not be able to be conducted if the water is contaminated. But let's face it, if it's contaminated, we all have a problem. We also heard witnesses, Dr. Kavika Liu and Kehaulani Kauni, who testified that the university and the TMT Corporation did not even consider, let alone analyze, the impacts resulting from high destructive development upon the landscape on the health, well-being, and well-being of Native Hawaiian people, especially those with high cultural affiliation, such as cultural practitioners. Cultural practices will be impacted. In this case, the actual injuries are cumulative, historic, and immediate. The cumulative impact was previously defined in our other court case, which was our federal court case, and Judge Mulway defined it, and she stated, cumulative impact is defined as the impact on the environment which results from incremental impact of an action when added to other past, present, and reasonably foreseeable future actions, regardless of what agency, federal or non-federal, or person undertakes such actions. Cumulative impact can result from other individually minor but collectively significant actions taking place over a period of time. Okay, thanks. She also stated that NASA's cumulative impact section, which takes up only 3 pages of a 125-page EA, does not include an appropriate analysis, finds further, however, that it is not only the effects of the construction of a particular project that should be taken into account, but rather the effects of any action as a whole. For instance, there is evidence in the record that the physical appearance of Mauna Kea's summit, or the viewscape, is of cultural and religious significance to Native Hawaiians, and the placement of the telescope has an adverse effect on the viewscape. Therefore, the effects of development of the summit would obviously last beyond the construction. Now, when we practice on Mauna Kea, we don't only go to the summit, as the university would have everyone believe. Practices are dependent on the reason for the ceremony being conducted, and the hundreds of cultural historic shrines placed around the summit region demonstrate practice is widespread. Viewplanes, viewscapes, and are public trust resources. The TMT being placed in the middle of the ring of shrines that contains hundreds of these sites will totally impact our practice. For example, from the ground level south to north, if you're standing on the ground level looking south, the TMT on the plateau from any of those ahus or cultural sites down below, your view of Haleakala and the other viewplanes will be impacted just by the sheer height of the TMT. If you're standing at ground level on the east side, we will not be able to see or observe the motion of the western stars and constellations without direct interference from the height of the TMT. And if you're standing on the ground level on the west side and any of the sites, you will not be able to see or observe the motion of the eastern stars or constellations because it would be directly interfered with by the TMT. And if you're standing on the ground level north of the TMT on the plateau for any of these sites, you will not be able to see or observe the motion of the sun and the stars or constellations without direct interference from the TMT. So from the pool level, you're going to have interference from the TMT as well. So I think I'm almost done. How much more minutes I have? 2 minutes, okay. If the BLNR allows the legal limits to be exceeded, they will be in breach of trust and in excess of their authority. And in the case, the TMT is not only the straw that breaks the camel's back, it's the elephant that will cause the entire system to break down. So in conclusion, I just want to say that when we began standing for Mauna Kea all those years ago, the kupunas told us that we must make sure to tell you all of the significance, because our kupunas believe that if you knew better, you would do better, and they certainly are right. We all know that our kupunas that have passed told us that we must continue to stand in aloha, and we do that here today. We extend our aloha to all of you. We know that this is a hard decision, and we will pray that you you will make the one we wish to hear. However, Akua, the mountain belongs to Akua, and Akua's will be done. And all we want to say, however, though, is that we have carried this inequity for a long time. We carry it because we even take it from the university. We carry it so much, but we cannot do that anymore. Our time has changed, and we just want everyone to know that we all will carry the inequity, any inequity that may flow from any of our actions or our decisions. We all do now. The world, the earth is calling out and saying no more. And the earth, Papa, is demanding. Come on. That we stand, and now is the time. And we will not give up. But we are here to say that it's time, and that's all we can say. So I'll close my pule mahalo kia kua, 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 for giving us this honor. Honor to stand. Excuse me for my tears.
They're the ones that need to be excused.
So, sorry.
Yeah, so I was just about to say, no need for any excuses. Questions? David?
Sorry.
Okay. Your testimony is really good, really good. You spoke of certain practices within the pu'u,
Yeah.
the pu'u level, in the different directions, and how the observatory would obscure or impact those practices. And since today was mostly, I guess, a summation of what was discussed or brought forth in the contested case hearing itself,
Yeah.
which we were a party to, and we only got summaries. Did you discuss those items within at the time of the testimony in front of the hearings officer?
Yes, definitely. We also list a lot of those practices in our petition, such as the solstice and equinox ceremonies, which have been being conducted by our kupuna for thousands of years. In fact, we just completed the one recently that closed the 23,000 year cycle of the procession, known as the procession. And yeah, those will all be impacted, actually, severely. And I believe actually the tourist view of the sunset will be majorly impacted. Anything from the north-facing side of the mountain is going to be impacted by that. And the views of Haleakala and the star constellations and all those things.
Thank you.
Okay.
Any question? Yeah, mahalo for your aloha. I'm
Yeah.
going to ask you the same question I asked everybody
Okay.
else. Should the decision stand, will you continue to go to Mauna Kea?
Well, yes, I will. Nothing can bar me from going there. However, that's a hard question. I will have to say affirmatively that our practices will be hampered, will be impacted, and in fact, some of the practices will not be able to be conducted any longer. And if that's the case, then we'll still, the ceremonies we do today are already adjusted for all of the other telescopes. Because actually the central place where the Kupunings used to do that practice was leveled on the summit. So where actually the Lele is now is already an adaptation. And yes, it's good that we could make that adaptation, but when we're losing those pools and we have nowhere else to go. So to answer your question, I will continue to go, but I probably won't be able to practice some of the practices any longer. Neither will other practitioners.
Mahalo.
Okay.
not sure if it is. I'm just starting to feel that.
Okay.
Like, well, they're gonna go anyway.
It's
So
not a-
why not?
It's,
Okay.
so it's a question that in my Hawaiian processing,
Well, in my Hawaiian
I needed to
processing,
ask.
I need to ask too, because I'm
Okay.
standing here with my children today,
So
and
it's,
I do not want that to come back to haunt me, that
Um,
I said I
yeah,
was still.
so
I'm
it's,
just asking.
it's
and
not a
thank
trick,
you.
it's, not- let me just
Okay,
explain.
everybody, it's not a trick.
All right, yeah, it's not a trick question,
Okay, that's
okay?
all I need to know, in good faith and
Well,
trust.
I
Thank
think,
you.
no, I think you need to hear
Okay.
the other reason. So when Clarence unveils genealogy, and then comes to my attention that that genealogy is connected, I have to ask that question, okay?
Thank you for clarifying that. I just didn't want to go home today and think that I was in church. So thank you so much.
You're welcome, thank you. Mahalo. Okay, so Tim, before you begin your rebuttal, there were two unsolicited documents that were handed to you. And I'm gonna give you the opportunity to object. So the first is from Kalani Florence, and he represented that this was a summation of his testimony that was given earlier. So I give you an opportunity, because it's unsolicited, to place objections onto the record.
Well, Chairperson Ayala, as a matter of record, I would like a copy for myself.
Correct.
And to the extent that it's a summary of Mr. Flores' oral argument, I would not object to it actually coming in. However, I would actually ask the board to disregard anything on this document which was not included in his oral argument. I believe that we are entitled, the parties are entitled to submit summaries. In fact, I think the court has actually asked for copies of the written summaries, so I think it's proper. But again, I would agree to having it submitted with the understanding that none of the argument is evidence itself. And if there's anything on this document that's not reflected in the oral argument as reviewed in the transcripts of yet, we ask that it not be.
And the second set of documents was handed to us unsolicited. Was described basically as Hawaiian Kingdom documents to the jurisdiction of international court. So you've had an opportunity.
I have seen that. Thank you. I would object to the introduction of any documents or presentations or any material submitted by anyone that's not a party to this. This is not a public hearing. It's not a public meeting. It's oral argument. I think that's the case. It would be appropriate to include that on the record as being part of the oral argument. It's not that I'm objecting to the substance. I have no judgment on the substance itself. It is actually what I believe is not an appropriate conclusion on this contested case.
Okay. Thank you. Actually, it's not necessary. Well, you're a party, so do you have an? Go ahead. You have.
So it's not relative to that one.
This is.
So what was initially sent submitted was a summary of our oral presentation testimony was dated February 12, 2013. And I don't believe that in the case of this oral arguments that the applicant can object to what we presented to the board.
He's only objecting if there is anything that wasn't in your presentation.
But why can I present something at this point in time as part of this 30 minutes or 30 minutes of those hearings?
Because it,
why is he allowed, applicants, legal counsel allowed to object to anything that is submitted?
because he hadn't had time to review the documents like all the other evidence that was put into the record.
Yeah, but neither does he have time to review the evidence or documents that people are presenting in the time they're given.
Well, Procedurally, he has the opportunity to object, and then at some point, we will, in our deliberations, rule on his objection in terms of what gets put in.
I just want to make that clarification. Okay, clarification.
And again, Mr. Flores has made the representation that this actually reflects his own argument itself, so I
Okay.
understand his concern.
Okay, so you now have your rebuttal time.
You have 14 minutes on the clock. You want to time check?
I would have to agree with Ms. Bishota's statement that there's nothing new that's presented by petitioners today. As she noted, that they have actually repeatedly been before the board, the department, on many of these claims. In fact, all of these claims, you will actually see that all the issues that they've raised has actually been addressed. All of these things were actually reviewed, considered, and considered by the hearing officer in his proposed findings of fact, conclusions of law that you have. And again, there's we believe that we have actually responded to them, and we'll rest on our opening statements that we made earlier, as well as the documents which we have submitted in response to those same claims, including our exceptions to our suggested exceptions to supplement the proposed findings of fact and conclusions of law, as well as our response to the petitioner's objections. Thank you. If there's any questions that the board has, we're available for answering.
Questions for members?
I would add one thing also, Chairperson Nyla. I would note that the board does have the discretion to deliberate now or vote now, and I understand that you've already made a statement that the board will deliberate subsequently on this. But I'll also join with Ms. Townsend's request that the board deliberate expediently and come quickly back to the parties for a determination on this. Thank you.
Okay, we'll take both of those requests under consideration. And with that, the hearing is now closed. Thank you very much.
Thank you very much.
Also, Heather.
Mahalo everyone. Mahalo. Mahalo ya opo. It's wasted on the university though. They only understand money. We always need money.
If anyone's thirsty, we have extra water. The board is well hydrated.
Thank you.
Right. I can't bring him on the plane, so. It was weird. It was like $1 a bottle and $4.50 for the 20. So,
Thank you, thank you.
thank you. And I kept calling you Paul. I don't know why. I knew that. You were responding, so I kept at it. And if you guys are thirsty, help yourself. We have.
Yeah, you know,
We're just on that
I laughed
Yeah,
when I
yeah.
can't borrow this. Remind me if I forget. Yeah, I mean, keep it real, yeah. This live broadcast will be recorded on so please share it. Also Mark. Mark or I just put your computer down. What's yours? Mine's from here?
So let's just go to politicize. It's not going to be. Oh, no.
That was in Craig, the outdoor circle.
Education.
So Marty? Yes, ma'am. Are you yeah. I'm sorry.
Hey, looks like you guys are all good. Okay. Take care. I know you're here.
Yeah, yeah, and help yourself to water because I can't bring them on the plane.
Thank you.
All right.
Okay.
Cool. Silly me thinking how much I was going to get done reading. I read some other book.
Got stuck in the
Oh, no.
Yeah.
Okay, we got it.
I think it's fun.
I had that once where,
First, let's talk about
like, they read the hearings on this, like, they're like, 1 hour, 2 hours, 10 minutes, trauma-filled 10 minutes.
Yeah.
So I was ready to get called out on it, and then nobody must have listened to me because they all wanted to copy it, like, not even the giant gap.
I did talk about that a year ago.
I know, and I think about it every year when I'm sitting
You're so sweet. Thank you.
They're there for cultural things. It's a ready-made audience.
Yeah, yeah.
Or maybe I just.
We only just maybe 50 minutes of that.
Are part of the audience. We had
Right.
But I had the battery went off. It went off. Did you get off? Oh,
There.
okay, thank you. Thank you.
Yeah, there's only one. I heard one woman making calls for the audience.
Yeah.
Yeah, I thought so.
But, you know.
Yeah.
But maybe in the
Never worked.
that would be
A lot of
fun.
investment.
Oh, is that right?
Good to have it in venue. Other places that are friendly, very powerful.
So what?
That's different. It's okay. I'll always make it back.
Yeah. You've been doing that stuff.
It's the other hand.